The writ petitioner, MS Lalmal Sawi, submits that the matter be listed on Thursday. Accordingly, as agreed to by the counsel for the parties, release this matter on Thursday. Give the date.
Item number 2.
Yes,
Services are not completed in this matter.
not complete.
Yes.
As per the office note. You are to as per office note 6826, AD card service is still awaited. Matter will be listed after 2 weeks. Mr.
Lodge. Lalven Sanga.
So and so appears for the writ petitioner.
Lodge, Your Lordship.
Item number
My lord.
3.
Sorry to interrupt, my lord. I am from Gauhati, my lord. Advocate Sandeep Chambre. My lord, one unlisted matter to be mentioned, my lord. Just now I have mentioned before the court number 2, but it was directly to place before your lordship the mention. May my lord allow to mention?
We are already in the midst of the proceeding.
Sorry. Actually,
You come back at 2 p.m.
my lord.
6 and 7 to file some affidavit.
Yes, Lordship. They haven't filed.
Are you filing the affidavit
Yes, Your Lordship will be filing within this week.
today,
Your Lordship, within this week, Your Lordship.
within this week?
Yes, Your Lordship. It is ready.
In deference to earlier orders passed by the court, affidavits required to be filed by respondents 6 and 7 are not yet filed. Learned counsel appearing for respondents 6 and 7 submits that the affidavit will be filed within this week. Considering the prayer made, matter will be listed after 2 weeks, by which date the affidavits as prayed for be filed by the respondents, and the petitioner is also granted liberty to file rejoinder, if so advised.
Much obliged, Lordship.
Released after 2 weeks.
Item number 4.
My lord, I am for the respondent number 1. I just received instruction yesterday. I may be given 3 weeks time for filing my affidavit.
You're the CGC?
Yes, my lord.
Yes.
With no objection, my lord.
Learned CGC submits that she has received instructions yesterday,
Yes.
and she'd like to bring it on record by way of an affidavit. Considering the issues involved, prayer made is allowed. Relist this matter after 2 weeks.
Lordship, I'm appearing on behalf of Mr. Caesar Ramsana, respondent number 2.
You're Mr.
Lalven Sanga, appearing on behalf of Mr. Caesar Ramsana.
So appears on behalf of Mr. C. Zoram Thanga. Chana, sorry.
Yes. And
For respondent number
for respondent 224.
234.
234.
All right.
And we have also received our instruction.
The private respondents will also, the respondents 2, 3, and 4 are also permitted to file their affidavit.
Lordship, if this
so
matter may kindly be fixed, taken up on 16th of September.
16th. Counsel for the petitioner submits that the matter be listed on a fixed date. He prays for 16th of September. Prayer made is not objected to. September,
If it's
Tuesday. Oh, sorry. You put a 25 list, what to do? 16th, I'm told, is a DP.
15, my lord. 15.
15, released on 15th.
Obligement.
Item number 5.
You remove this 25 list. Yes.
Yes. Your Lordship, I'm appearing on behalf of the appellant.
Respondents 1, 2, and 3 have not filed their counter affidavit.
Your Lordship, the present matter may be withdrawn. The present matter may be withdrawn.
You want to withdraw
Because
this
it's-
matter?
Yes.
Okay.
In fact, my lord, in this case, I'm appealing for the private respondents. The matter has now become infructuous. It can be withdrawn.
Okay.
That's my
Counsel for the petitioner submits that his instructions to withdraw the writ petition. Mr. Victor, learned counsel appearing for private respondent, submits that the writ petition has become infructuous. Accordingly, considering the submissions made, writ petition dismissed on withdrawal. Interim orders, if any, stands vacated. Pending IAs are also dismissed.
Much obliged.
Obliged. Sure.
Item number 6.
Your Lordship, this is an application for condemnation of delay of 102 days in filing the RFA.
There is an objection filed.
Yes, Your Lordship.
Yes, my lord. I have filed.
Delay of 102 days.
Yes, Your
How
Lordship.
have you explained the delay? Let us see.
Your Lordship, the explanation is from page 4 of the IA, paragraph number 3 onwards. Your Lordship, initially the judgment, although the judgment was pronounced on 22nd of November 2024, decree was drawn only on 13th of January 2025. Thereafter, the applicant came into physical possession of the judgment and order on 16th of January 2025. Thereafter, during the trial, the main appellant herein had passed away, and she was substituted by 3 of her children.
On which date?
Your Lordship,
Prior to the judgment or after?
prior to the judgment, during the trial, she was substituted by 3 of her children. So there was some logistical complications in communicating this decision to be taken up by the appellants herein, the people who had substituted the deceased Romori, because there were 3 of them. So, and after taking some time, they approached their counsel in the trial court as on 17, after about taking about 1 month, they had approached their counsel in the trial court, but since that counsel was not practicing in the high court, they had to approach another counsel. So he came into contact with us, as in with the present counsel, sometime towards the end of February. And then since there were some personal difficulties faced by the counsel during this time due to personal matters, there was some delay caused by the counsel, as enumerated in page 5, sub-paras number 3, 2, 3, and 2 and 3. So, Your Lordship, towards the end of May, the photocopies of the relevant documents were obtained. And
When did you apply for the copies?
towards the end of May,
There must be specific dates. How did you get hold of these copies?
certified copies were actually applied for on certified copies of the judgment and order were applied for on 23 of June, 23rd June, but other documents, specific dates were not, because they were obtained on different dates. They were obtained sometime in the month, towards the end of May, but then the actual, the certified copy on folio format was applied for on 23rd June and was issued on 4th July. And then after that, Your Lordship, at page 6, the court vacations had started from 7th of July. And after resumption of court on 14th of July, the counsel started immediately preparing and drafting the appeal, which was finally completed on 21st of July. And the appeal was finally filed on, after making necessary some final corrections, the appeal was finally filed on 23rd of July, resulting in a total of 102 days of delay. So, Your Lordship, our main submission in this IA is that there was no negligence on the part of the appellant, but the main fault is attributed to the counsel who had filed the appeal, who had filed this appeal. So there can be no fault attributed to the applicant herein. That is the main contention.
How do you respond to the objections raised by the opposite party? They've relied on some judgments also. How do you distinguish it?
Your Lordship, with regard to the citation mentioned in page number 6, para 8 of the written objection, as stated earlier, it is our submission that there was no negligence on the part of the appellant, because he had acted in due diligence and he had performed his duties. He had approached the council within the time frame, and there was no willful negligence on his part. It was the fault of the council that the delay had been caused, and during this time he had kept inquiring about the status of the appeal, but due to the personal problems faced by the council, the appeal could not be filed within time. That is in response to the citation given in para number 8 of the written objection. Because there was no malified intent on the part, and Your Lordship, even though I have not placed it on record, there is one citation which says that the delay would not benefit the appellant in any manner whatsoever. So there is, even in our case, there is nothing which would which would.
What was the judgment?
The judgment was regarding a land dispute, and it was regarding the sale of a property which was in our favor. So the property had been mortgaged in our favor, and then it was later mutated by us. But the mortgage deed itself was declared null and void. So we had paid the price for the property, and we had been in possession of the property. However, the process by which the property was given in our favor, was mutated in our favor, was declared null and void. Therefore, we are the bona fide purchasers of one property, and we have been we have paid the price, and we have been left without the property at this stage. So the main appeal is also for either recovery of money or recovery of the property, because we have been left with nothing, even after paying the consideration for
The
the.
land belonged to your mother.
No, the land belonged to the, as of now,
Defendant number 3, who's defendant 3? You're the children of defendant 3.
yes, we are the children of defendant.
So who holds the LSC?
The LSC was originally in the name of the respondent number 1.
Okay.
And it had been mortgaged by her husband, who is the. Respondent number 2. Thereafter, the respondent number 2 had mortgaged the property in our favor, and we had let the respondent number 2 borrow money from us also. But since he was unable to repay his debt, the property was then mutated in our favor. But then the issue is that the process of mutation was declared null and void. So even though we had given money to the respondent number 2, the respondent number 1 had been declared as
Who's the appellant?
the appellant is, as per in the civil suit, the appellant is the children of the respondent number 3, the defendant number 3.
Okay. Yes, respondents, what do you say?
May I please, Lordship. My Lord, I would like to take your Lordship to Section 5, under which the instant application is filed,
Limitation.
Limitation Act, my Lord. Section 5 of the Limitation Act.
Limitation Act. Here somewhere. Thank you. Yes,
My Lord, with Lordship permission, I'm reading.
yeah.
Extension of prescribed period in certain cases, any appeal or any application other than an application under any of the provisions of Order 21 of the CPC may be admitted after the prescribed period if the appellant or the applicant satisfies the court that he had sufficient cause for not preferring the appeal or making the application within such period. My Lord, I would like to emphasize, if he had sufficient cause. In the instant application, my Lord, the applicant does not seem to have any sufficient cause. My Lord, as per the Supreme Court ruling, in the case of Baswaraj and another versus Special Land Acquisition Officer, Para 9, I'm just reading up. I've made the requisition for the citation memo. Sufficient cause is the cause for which the defendant could not be blamed for his absence. The meaning of the word sufficient is adequate or enough, inasmuch as may be necessary to answer the purpose intended. Therefore, the word sufficient embraces no more than that which provides a platitude which, when the act done, suffices to accomplish the purpose intended in the facts and circumstances existing in a case, duly examined from the viewpoint of a reasonable standard of a cautious man. In this context, sufficient cause means that the party should not have acted in a negligent manner, or there was a want of bona fide on its part in view of the facts and circumstances of a case, or it cannot be alleged that the party has not acted diligently or remained inactive. My Lord, in the present case, as we can see from the application itself,
Since you are reading para 9, you may read para 11 as well,
my Lord,
of the judgment. Page
2013, volume 14,
Yes, page 86.
page 86. Yes, my Lord. '86, yes, my Lord.
Para 11.
Starting from para 9, my Lord. And para 11 also relevant. I'm reading para 11. The expression sufficient cause should be given liberal interpretation to ensure that substantial justice is done, but only so long as negligence, inaction, or lack of bona fides cannot be imputed to the party concerned. Whether or not sufficient cause has been furnished can be decided on the facts of a particular case, and no straitjacket formula is possible. My Lord, what I'm trying to emphasize from this point is there is no explanation as to why the applicant has obtained the certified true copy of the impugned judgment in order from the court, even within the permissible period of 90 days. As Your Lordship can see, the impugned judgment and order was passed on 22/11/2024, whereas the applicant applied for the impugned, the certified true copy on 23/6/2025. That is more than 100 days have passed from the date of the impugned judgment in order, my lord.
He has given his explanation in the IA.
My lord,
Para 4, he's attempted to give his explanations.
and my lord, I have given a reply to all those explanation, which according to us is not sufficient for condonation of delay of 102 days. And my lord, in the other points also, the counsel was out of station or on professional duties, no supporting document. And since they were in the para 4, para 3, clause 4, the applicant obtained copies of the judgment and degree evidence plain towards the end of May 2025. There were several documents. The case requires extensive research. He had to meet up with the applicant on several occasions to discuss the case as well. According to us, my lord, this cannot be considered to be a sufficient cause for delay. And my lord,
Is there any other appeal filed arising out of the judgment and order decree?
No, Your Lordship. No.
No other party. There are about 2 or 3 different dependents there,
my lord,
as I can see. No other appeal.
no other appeal, my lord. So my submission to your lordship is the applicant does not have any sufficient cause to condone the delay of 102 days. My lord, and since I brought a few rulings with me, I may be permitted to produce and rely the same. ICICI Lombard General Insurance Company Limited versus Rupnath Brahma Chaudhary and another, reported in 2017, Volume 2, GLT, page 487, paragraph 4.
Can you repeat the paragraphs again?
Paragraph 4.
I'm sorry, the citation?
Citation, ICICI Lombard General Insurance Company Limited versus Rupnath Brahma Chaudhary and another, reported in 2017, volume 2, page 487. Relevant paragraph is 6.
Yes.
Paragraph 6, my lord, I'm reading. It's not very long. The explanation as given in herein before quoted paragraph number 4, 5, and 6 of the instant application are not at all found to be satisfactory. From insurer like the appellant who are in business of insuring citizens and goods in the country have a special responsibilities to see that at least they do not become a source of prolongation of a litigation under the social and beneficial legislation. Accordingly, this court is of the view of the opinion that the reasons assigned as the cause of delay establish that the delay of 99 days has not been properly or satisfactorily explained. The said causes are held to be held not to constitute just or proper or good or sufficient cause for which the connected appeal could not be filed on time. Rather, the said statement reflects that the applicant was casual in all stages of decision-making process in the branch level, regional office level, and in the head office level. And in the same book, my lord, one more ruling I'd like to place. State of Assam and others versus Gita Rani Kalita and another, 2017, volume 2, the same book, GLT, page 1190. This is the ruling passed by the division bench of this on report, para 9, my lord. State of Assam and others versus Gita Rani Kalita, reported in 2017, volume 2, page 1190, para 9.
Yes,
Para 9 is relevant to my present case.
yes.
With your lordship permission, the certified copy of the impugned judgment order dated 6/1/2015, annexed with the memo of appeal, reveals that application for same was made as late as on 25/5/2016. That is after 1 year, 4 months. No explanation is given why application for obtaining certified copy was not made within reasonable time. More particularly, when the order was passed in the presence of learned counsel for the applicants. My point, the point I would like to emphasize in the present case is judgment and order was pronounced in presence of the rival counsels.
They
And
were
it is-
already arrayed as substituted in the suit before the judgment.
Yes, Your Lordship.
You were.
So, since the present applicant has failed to obtain, applied for certified true copy in time, the present ruling which I have just cited is relevant, my lord. And the last ruling I would like to place is Union of India versus Tata Yodo Gawa Limited, reported in 2015, volume 9, SCC, page 102. Para 5 and 6, my lord.
Yes.
It is further stated in the rejoinder affidavit to the counter affidavit on behalf of the respondent that such delay is always beyond the control of, especially in government matters, as the file has to be routed through several sections of the department. We are aware of the fact that the government, being impersonal, takes longer time than the private bodies or the individuals. Even giving that latitude, there must be some way or attempt to explain the cause for such delay. Paragraph 6, as stated from the facts narrated herein above, there is no sufficient cause to explain the delay. Hence, the application for condonation of delay, that here 51 days delay only, my lord. The application for condonation of delay is dismissed, although it is just 51 days delay, my lord. So with that, I conclude my submission to your lordship. Taking into account the ruling passed by the Supreme Court in those cases, my lord, the present application is without any cause, sufficient cause for delay, for condonation of delay, my lord. So I pray your lordship to dismiss the application outright.
Your Lordship,
Yes.
if I may be allowed to make a short rebuttal to the cases relied upon. With regard to the case relied upon regarding the ICICI case, It is my submission that, Your Lordship, that case was against the company, and the act relied upon in the case was some beneficial legislation, which is in favor of the society, so which is entirely different from the present case. That because that case was for the benefit of the legislation, such as Consumer Act probably, or some other act. So in that case, the disallowing of the condonation application would not be in the same premise as the present case. And with regard to the judgment cited in the written objection at para 8, Baswaraj versus Land Acquisition Officer. In that case, as my learned friend, learned senior counsel had read out, at para 11, it has also been stated that liberal approach should be adopted and that there is no straitjacket formula. And that even in the paragraph cited in the sentence cited in the paragraph number 8, there is nothing to suggest that the applicant had acted negligently and he had remained inactive, because as stated in the application for condonation of delay, the applicant had taken all his steps and he had approached the council within the limited time or within the time frame, but it was due to the inaction and inability of the council that the delay had been caused. And the other case which was relied upon regarding the certified copy being applied for after 1 year. In this case, the certified copy was, the judgment was, although the judgment was pronounced on November, the decree was pronounced only, was delivered only on January of the next year. So the certified copies were applied for in the month of June, which is after 5 months. And moreover, Your Lordship, the responsibility of, in particularly in Mizoram, the responsibility of obtaining certified copies is on the council. And the applicant, being a layman, would not know the procedures of obtaining the certified copies or the requirements thereof.
Did you file any complaint before the Bar Council or the association that council was negligent? Nothing.
Your Lordship, I am the council.
You're the council.
Yes, Your Lordship. So it was my inability that the delay had been.
You're admitting it is your,
Yes, Your Lordship.
we are not taking that onto account. All right, we'll pass orders on Thursday.
Yes, Your Lordship. Obliged.
Third council for parties, list on Thursday for orders.
Obliged.
Item number 7.
I will go to my chamber. Yes.
Lordship, as per the previous order, I was directed to take fresh steps. In respect of respondent number 3, steps has been taken. And regarding that newspaper publication, newspaper publication is under process. So,
There was a direction to take, give the correct address.
yes.
Is that the correct address of respondent 3?
As far as I know,
Respondent 3,
respondent number 3,
that steps you have taken, is that the correct address?
as far as we know, that is the correct address.
All right.
But we cannot assure.
Then when are you proposing to take steps by substituted means, by newspaper publication?
If I may be given 1 month's time.
1 month's time. Yes, respondent?
Lordship, I'm for respondent number 1 and I have no objection, my lord.
Okay. You're Mr.
KLL Indiana.
Mr.
KLL Indiana.
Counsel appearing for the petitioner submits that this is an appeal.
Yes, yes. Mega appeal.
For the appeal, appellant submits that fresh steps on respondent 3 has been taken in the address which the petitioner counsel believes to be the correct address. Stock fee further submits that steps are being taken for publication of by for service of notice by newspaper publication, for which he requires a month's time. Which newspapers are you
From Assam newspaper,
from Assam?
because
They're in Kachar, Kamrup. The petitioner is permitted 1 month's time to take all steps for newspaper publication. Publication must be made in how many dailies was it directed?
number of newspaper was not specified in the previous code.
You're for the company.
Yes, Lordship.
You take make the publication by way of 2 newspapers.
Oh.
Publication be made in 2 newspapers having sufficient circulation in the areas where the respondent 1 and 2 respectively reside. So publication shall be made in 1 English daily and 1 daily, vernacular daily, having wide circulation in the areas.
Lordship, I think if we can fix next date, I think it will be better
Which one?
for that for this case. For next date, next court date, I think.
No, we are permitting you 1 month's time as per your request, directing you to make the publication in 2 newspapers. And we are fixing a date.
Okay.
Matter be listed on, give us a date in September, what is convenient for you?
Maybe 22.
22. Let it be on 15 September.
That
No,
is
1 month.
Lordship, that is less than 1 month.
1 month. All right, 21st of September.
Okay, thank you, Lordship.
Item number 9. Sorry, item number 8.
My Lord, I'm appearing on behalf of my senior, Mr. A.R. Malhotra. We have received the paper book and the matter can be listed for hearing.
Paper book has been prepared and the counsel for the parties have received paper book. The matter is ready for hearing. Matter be listed for hearing in the month of September.
All right. My Lord.
In the, do you want to list it in the part 2 hearing list or
Yes, my Lord, part yes.
in the part 2 hearing list for the month of September? Relist accordingly.
Item number 9.
May it please your lordship, I'm appearing on behalf of the state appellants. Your lordship, the conducting counsel, Mrs. Emily, she's on leave till the 31st of August and we have received the TCR. If this matter may be listed in the hearing column in the month of September, your lordship.
Any paper book necessary? Ready?
It is ready,
You have received
Yes,
paper
Your Lordship.
books. Paper book has been prepared by the registry and supplied to the learned counsel. Matter be listed for hearing in the month of September in the part 2 hearing list.
Yes, lordship. Much obliged, lordship.
Item number 10.
May
Yes.
please, Your Lordship. My Lord, we have received the paper book and the matter may be listed for hearing, my Lord.
On 3rd of September, if possible, Lordship.
3rd September is good for you?
Yes, my Lord.
All right. Paper book supplied to the respective council. Matter be listed for hearing on 3rd of September. As agreed to by the
Obliged.
for the parties.
Item 11.
Lordship, we will be filing our affidavit in opposition during the course of the day. And TCR has been received.
You're filing affidavit here in an appeal.
Yes, Lordship.
Is it necessary?
Not much, Lordship.
Because the TCR is
My
there.
lord,
but
If
perhaps a
paper book can be prepared.
Paper book is necessary.
Yes.
Yes,
paper book may be
Lordship.
prepared, my lord.
So do you still want to file the affidavit or
We are for the respondent number 7, a private respondent.
all right? Counsel for appearing for the petitioner, Mr.
If la Langliana, my lord.
appears for the petitioner. Senior counsel assisted by MS so-and-so. The trial court reports have been received. Registry will prepare the paper book and ensure supply thereof to the counsel for the parties. Meanwhile, private respondent number 7
Yes, Lordship.
seeks liberty of the court to file an affidavit. Prayer made is allowed. Release this matter after 1 month. How much time does it require for the paper book? 3 weeks?
Usually a month, my lord.
1 month.
My lord.
Matter be listed again after 4 weeks.
My lord.
Registry will make necessary endorsement regarding supply of paper book to the respective counsel.
Obliged, Lordship.
Item number 12.
May I please, Your Lordship? Your Lordship, this application is filed for release of statutory deposit amounting to rupees 25,000, which was submitted by the applicants in MEC Appeal number 8 of 2025. And this MEC Appeal number 8 of 2025 had already been disposed by this Honorable Court on 12/2/2026.
Matt appeal
Number,
disposed.
yes, Your Lordship.
Is it dismissed?
Yes, it was the learned tribunal's judgment and award was upheld.
Upheld.
Yes, Your
What
Lordship.
was the judgment and order?
The judgment is starting from annexure 1, page 9 to 26.
You're for the appellant.
I'm for the appellant, yes, Your Lordship.
Yes, what do you say?
Yes, my lord, we have no objection.
But this is to be released to the respondent.
No, Your Lordship, not to the respondent, to the appellants, to the applicants.
But you say the finding of the tribunal was upheld.
Yes, Your Lordship.
What was the
It
direction?
was upheld and rupees 23 lakhs 30,000 along with interest was awarded to the respondent, and that was already been paid. And while filing this MEC appeal number 8 of 2025, Your Lordship, rupees 25,000 was deposited to the registry of this High Court.
Why the compensation amount has been released?
Already released.
Released.
Yes.
Are you sure there is no deduction of the statutory deposit?
No deduction is there.
Sure.
Your Lordship. Yes, Your Lordship.
No, I heard. Counsel for the parties, this IA has been filed on behalf of the appellant, by the applicant, who was the appellant, in MAC 8 of 2025. By the said application, direction is sought for release of 25,000, which was deposited by the appellant as a statutory deposit while filing the appeal, connected appeal MAC 8 of 2025. Stop. It is submitted that by judgment and order dated 12/2/2026, the appeal was dismissed and the judgment and award passed by the MSCT Isol in MSC case number 38 of 2022 was upheld. Stop. It is further submitted by the learned counsel appearing for the applicant that the amount has already been released to the respondent. Where is that statement you have made?
Your Lordship, at para 3, 4, and 5. In this application, I have not mentioned that, Your Lordship, the compensation had been disbursed to the respondents. I have not mentioned in this application.
You show us some document or whatever, some communication.
Your Lordship,
Yes, we have received the amount, my lord.
You have received.
Yes.
All right, counsel, learned counsel for the applicant submits that the compensation amount has already been released. That is your submission
yes, Your Lordship, my
on the
submission.
basis of instructions received, and the statutory deposit has not been adjusted. Era. Counsel appearing for the respondent on the other end acknowledges the receipt of the compensation amount in full. In that view of the matter, there being no dispute as the compensation amount being released pursuant to the dismissal of the MSc appeal, whereby the MSCT judgment and award dated so and so by MSCT ISOL was upheld, the IA stands allowed, the registry will refund the statutory deposit.
Your Lordship, along with interest, if any, I have stated in my prayer portion at page 5.
We decline to give you interest, only the principal amount
Yes, Your
of
Lordship.
25,000 without any interest to be released to the applicant/appellant upon furnishing adequate documents regarding identity and the particulars of the bank account to which the amount is to be released. Disposed.
Obliged.
Interest declined.
Item 13 to 14.
My lords, these are matters fixed for hearing. Your lordships may be seeking your lordship's indulgence. My lords, if your lordships may find it convenient to dispose of this matter, it's a 2024 matter. My lords, here basically we had challenged the recruitment process undertaken, my lords, by the MPSC, which is the State Commission, Public Service Commission. And it was for, my lords, the post of junior grade in different departments, my lords, police, civil services, the Mizoram Civil Service, Mizoram Police, Finance, and, my lords, the information services. So, my lords, all we will show, my lords, through the petition, what irregularities have cropped up while, my lords, the process was undertaken.
My lord, before he goes further, actually, my lord, this petition became infructuous. In fact, on one occasion, the court directed to withdraw the case also. My lord, the petitioners already were appointed. After this exam, which has been challenged, there are two another exams. In the petitioner 1 and 2, they already qualified. Because in Mizoram Public Service Commissioner, advertisement was on the vacancy base. Because that 2023, after that, this is impugn examination. After that, they applied. Because they applied and they are qualified. Because when 2024, when advertisement was made, and only on the basis of that 2023 made, they applied and again got selected. In fact, they're not satisfied. One is Mizoram Finance Service and one is Mizoram Public MPS. And again also, my lord, in 2025 examination also, that petitioner 1, again after MFNA is not dissatisfied, applied into the third examination. Even he got selected. He was already selected and joined the post, got appointment as the top 1 MCS. What is there to argue at this stage? Since it became already infructuous.
Now, my lords, let
They
me
are now
clarify.
joining, they have been serving as
Because my
Mizoram
learned friend
Public
is
Service
mistaken.
Commission. Even one petitioner was serving as Mizoram Civil Service Commission since
I
2025.
think my friend has made his point, my lords.
My lord, I have
Let me just-
the appointment letter too.
My lords, we don't dispute that.
How can we turn back the clock?
We are not turning back the clock.
No, he is trying, because that
This is a
2024.
misconception, my lords.
No, my lord,
A misunderstanding.
2024,
Submit one by one, let him submit.
my lord, 2024, those were selected. If this recruitment process is set aside, in case then those who are able qualified, because in that 2024, they are in panel list number 1 and 2. What about the rest who were qualified, were recommended, who joined the service in 2024? Because since they did not pray for stay, any other things, they joined the service and they have been serving as Mizoram Service MCS, MPS, MFNS, MIS. Then even some of them, in fact, they might get already promoted also. Then if this petition is allowed, then that they will definitely suffer. Those petitioners, the selected candidate in the year 2024. There is nothing to challenge. That's why the court also inclined to dismiss, and the councils asked for some more time to seek instruction from the client. Unexpectedly, another second petition, they file it again.
Now, my lords, let me clarify the factual position. My lords, what had happened was in 2023.
My lord, before you go further, can I allow me to furnish the appointment letter?
My lords, if I may.
That's
My lords,
2025 and 2026
my lords,
recommendation.
my friend
letter.
may not interrupt now, my lords.
Okay, then I'll raise it. That preliminary submission only. That is.
No.
Merit, I'm ready to argue also, Lordship. I'm not running away.
Oh, my lords, what had happened was in 2023, if your lordships has the...
I mark it 19 and 30. MPS.
Your challenge was with regard to the selection process where you were not
Yes.
selected.
My lords,
You were not
I
selected.
was not selected. I made it to the interview.
Right.
After the final declaration was done, my lords, we had, my lords, seen our answer sheets. We saw how much marks were given. Your lordships, we were very surprised to find, my lords, whiteners being used on the tabulation marks, on the tabulation slips. Your lordships would have seen, my lords, in different states, my lords, certain discrepancies occur. And my lords, selections are also cancelled. But my lords, there either the answer keys are different to that, what was answered. Those are there, my lords. Out here is a different spectrum altogether, my lords. Use of whiteners, changing the marks, my lords. You tamper the marks, obviously, my lords.
That is wrong.
My lords, I'll show. He may object at his, my lords, at his time. Now, my lords, let me just put the facts. Your lordships may have the list of dates at, my lords, page C. Just for my lords.
No, now tell us.
Yes.
You don't dispute that you are now employed,
I am
selected
employed
by the subsequent exam.
in the subsequent years.
Right.
True.
So you are presently employed.
I am employed.
What is your claim for the challenge now?
My lords, Article 14 and 16, your lordships knows that, my lords, there has to be, my lords,
No,
fairness.
hypothetically,
Yes. Yes.
let us say we allow your petitions.
Yes.
What happens? There has to be a re-examination
Yes.
of that 24 exam
Yes.
where you will probably participate.
Participate.
We will not be able to give you a direction, assuming we
Yes.
accept your submissions and allow the writ petition.
Yes.
We will not be able to give you a direction that your appointment should be given effect from 24.
Subject
be
to
done.
the outcome of that.
That can't be done because you had reached only the interview,
Yes.
right?
Yes.
There was no selection. Therefore, you are before the court.
Yes.
So, assuming we allow the writ petition, we interfere
Yes. Yes.
with the select list or whatever, we direct, our direction would be restricted only for holding a fresh selection,
Yes. Yes, my lords.
which technically today
Yes.
doesn't appear to be a very practical issue because you're already employed.
My lords, it is there. That is true. Your lordships, what had happened in before the Honorable Manipur High Court also, which went to the Supreme Court, 2016 recruitment was set aside. The matter went up to the Supreme Court, my lords, and the directions from the Supreme Court was that, my lords, you conduct the mains examination afresh because of the irregularities there.
Entirely different.
So, my lords, ultimately, my lords, I'm saying, my lords, your lordships may see the violations, your lordships may see the discrepancies. Subject to that, my lords, your lordships, we leave it up to your lordships what directions flow. Because ultimately, my lords, selection is totally, my lords, arbitrary, my lords.
No, we are not saying that.
Yes.
This writ petition, this is not a public interest litigation.
No,
right?
no.
This is at the hands of a of a candidate or some candidates were not selected,
Yes, because of alteration of marks.
whatever. Now, assuming we allow the writ petition,
Yes,
the probable direction would be to go for a fresh examination or interview, whatever it is,
yes, yes.
where you will be given permission to appear.
Take part. Yes,
Even if you appear, there's a possibility you may not be selected,
yes, my lords, that chance is there.
right?
I agree, my lords.
Now, if you are selected,
Yes.
then the next question would be what happens to the service that you're undergoing now?
My lords, I forgo that. I forgo that, my lords. Because, my lords, ultimately, my service would have to be counted from a particular period for a particular recruitment year, my lords. Your lordships may just see what our petition
Had
is.
it been a PIL, maybe we would have
My lords, now the problem.
gone into. But
Yes.
now that your advance primarily is seeking your wrong rejection, your wrong rejection may not be answered, but subsequently you have been selected. You're now serving.
For a difference, which we also challenging in the second writ at item 14, we are saying your lordships may look at the petition, look at the inquiry report. It seems this malpractice irregularity is done on a large scale. Your lordships may set it aside. And my lords, insofar as the further consequential relief of my lords re-examination, my lords, that we leave it up.
Where
to
is
your
the
lordships.
inquiry report?
My lords, that's at item 14, if you lordships may see.
14. 14 is the next
But
item.
in this petition, in my counter affidavit, I have enclosed.
You have enclosed.
Yes, I have enclosed. My lord, it start from 36, annexure number 2. So the report is from 37. That is that original vernacular language, and the English translation is start from
So your lordships
40,
sees this, my
50,
lords.
53.
May we just place our case? Very short.
Yes. Where is the report? Let us see the
It
report.
start from 53.
53. This was an investigation undertaken by whom?
By the, actually that is
My
ordered
lord,
by
State
the
Vigilance
Vigilance
Department. State Vigilance Department, my lords. They have, my lords, appointed one ex-chairman of the MPSC itself, who is a retired IS officer, my lords, to look into it.
In fact, my lord, in the report, the order, they are not aggrieved. In fact, they are very happy. They sought for submission of additional
well, my lords,
documents.
if we are
No,
happy, we
no.
won't be
After
challenging.
that, when the report came, they are dissatisfied. Initially, even they submitted application to the court to place on the report also, in the record also in the case. They filed it. Then when result came, the report came. After that, they say that we are not accepting the report. My lord, they filed petition without going first to representation, any approaching us due to their ignorance of our process, our procedures. Had they know our procedures, definitely they will not come to the court.
My lords, we just,
MPSC is very fair, and that's why they did not understand how fair we are.
your lordships may just give me 5 minutes to place our facts.
My lord, allow us.
And I'll come to this
start from
inquiry
53. The report starts from 53. We'll see very clearly how detailed, minute, everything. When we rely upon this report also.
Let him submit.
My
Lordship,
lords,
that's fine.
if your lordships may come to, my lords, our petition for a minute, my lords, I'll come to the inquiry report and how it is bad, my lords.
What was the ultimate conclusion in the report?
That, my lords, there is, my lords, basically today there is no rule or procedure insofar as scrutiny of papers. So, my lords, what the inquiry report did was that it had explained the steps taken by the commission. And the whitener, the utilization of whitener and whitener ink, my lords, that has been, my lords, justified through the inquiry report. But, my lords, the inquiry report failed totally to look at a specific allegation. If your lordships may kindly see the writ, my lords.
Yes.
Page 64. Page 65, my lords, if your lordships may come. This is petitioner number 1's answer script and the, my lords, final tabulation slip by the scrutinizer. Your lordships may see page 65. Your lordship sees in the first column, question number 1 marks whitener. In the, my lords, parallelly, again whitener. My lords, this goes to the root of the matter, my lords. Secondly, my lords, if your lordship
Through the whitener,
yes, they've altered the marks.
possibly, as far as I can see,
Yes.
it's about 71 marks or something like that.
Yes, yes.
But you've been given subsequently 76.
Yes.
So there's an increase in the mark rather than reduction. Is it?
My lords, frankly, my lords, if your lordships will come to the inquiry report, I'll come there. There are supposed to be 2 evaluators. They'll both give marks, my lords. Thereafter, these 2 marks will be scrutinized by the final authority, which is called the scrutinizer. He'll, my lords, give the total at the bottom, which your lordship saw at page 65. So, if your lordship sees, if there was a need to employ whitener at page 65 in the first column, why was there a need to employ a second, employ the whitener in the second column again? If that was the wrong mark, then why did you use again? We do not know what's behind this 76.5, my lords. It could be more, less.
Oh, you're saying there's another whitener
Yes, yes, your lordships
on
may
which
see.
76.5 is
Yes,
written?
yes, my lords. Your lordships would see it's written in red. At the bottom also there is some scratching. Because, my lords, we had filed an IA also because we couldn't get better copies than this. The commission would not allow us certified copies for the first time in 2020.
These answer scripts are not available for retabulation?
My lords, we had filed an IA. Justice Nelson had allowed the IA limited. It's still pending, IA 49. Therein he said, my lords, you may not dispose it of unless and until leave of this court is granted to dispose. So, my lords, the answer scripts are still with them with the tabulation marks. They can do that.
You retabulate and come back. Can you retabulate?
My lord, no, that is, because if you read the inquiry report, you understand. The thing is that there are 1 examiner, 2nd examiner, and the 3rd evaluators are there. Because by mistake, the evaluator write on the paper itself. So they erase it. Because this has been done because it has to go again to 2nd evaluator. So this is by mistake, we erase it.
By mistake.
Because, my lord, I'll explain. Then for the 2nd examiner to use his independent mind, not just to rely on the 1st evaluator, then we erase it, that the white mark.
No, my lords, I'll come to that.
To be more fair.
Your lordships may kindly have page 132 again.
No, that is what, because it is ignorance of our process. We
don't have a process, that's the problem.
No, we highlighted.
Learned counsel is ignorant of that.
No, I am ignorant of the.
Page 132, my lords. Just for a second. Your lordships would see there again how the whiteners have been. 132.
132.
Yes.
Yes.
Now, my lords, your lordships would see in the first column, 12, how it's being employed, the whiteners, and the total also. This is the final slip. I'm coming to the procedure through the inquiry, my lords. I have no issue. I'll definitely, my lords, address that. And lastly, my lords, at page, this is, 1 second, my lords. Now, page 193, my lords. Page 193.
Hmm.
193, your lordships would see with black sketch ink, they've, my lords, totally changed the whole marking. And, my lords, just to give a complete, my lords, understanding of the whole facts of what was happening in the preceding years, your lordships may come now to, my lords, page 211. This is for preceding years, my lords, 2022. Petitioner number 2 had taken part in the 2022 recruitment. What was the, my lords, the way of tabulation? Your lordships would see, there is no use of any whitener black sketching. If at all it was to be altered by any chance, my lords, page 231. And I'll come to the inquiry report thereafter. Your lordship may just have this, page 231. Your lordships has it? If, my lords, there was to be an alteration of marks, your lordships may see at serial number 6, it has to be countersigned. Similarly, at the total, it can be changed. I'm not saying it can't be altered, but again, with the signature of the scrutinizer. So, my lords, today, because of this, my lords, it had affected our total marks. Therefore, the selection, my lords, definitely would be affected, my lords. And, my lords, the inquiry report himself says, I'm coming to that now. Inquiry officer himself says, I've checked top 50 of the persons selected who came to the stage of interview. He himself says that the whitener was being used. But since it involves, the scrutiny involves a 3-stage process, they call it first evaluator. He gives his marks for each answer, each question. He gives his marks, no issue. When the answer script is then given to the second evaluator, who again gives his marks, my lords, independent. What had happened is, the way they try to justify this whole scenario is this, my lords, that when the first evaluator gave his marks on the slip, this is the final slip, there's a separate slip. On that, my lords, so that the second evaluator is not influenced by the marks given by the first evaluator, they had, my lords, used those whiteners. But today, what I've shown your lordships is, after the first and second give, lastly, it is moderated if required. Then it is finally tabulated in the final slip given by the scrutinizer. So you have first, second evaluator, scrutinizer. What I showed your lordships is the final scrutinizer slip. My lords, when there is a final scrutiny process, where is the question of again using the whitener and trying to alter marks and again retabulating? These are experts, allegedly. And I'll show that from the counter affidavit of the MPSC, my lords. Your lordships may have the counter affidavit of the Mizoram Public Service Commission. And your lordships may have at para 18, at page 17 of their affidavit, what the process is. This was, my lords, part of the inquiry report. It is parameteria reproduced here. Page 17.
70.
17.
17 of the counter affidavit.
Counter affidavit.
It's an parasa same.
Para 17. It starts at para 18, my lords. That in reply to what has been stated in petitioner wrongly alleged commission of tampering the answer sheets indicating 3 specific point of allegation. This is mainly due to ignorance of the system of evaluation in recruitment examinations conducted by the commission on part of the petitioners. Unfortunately, today, no written rules. Process of evaluation in the commission may in short be summarized as under. This is their, my lords, the way they've justified. Commission has a system of 3-stage evaluation in direct recruitment. We are direct recruitment. 2-stage evaluation system in limited departmental examination and single-stage in departmental examination. In direct recruitments, where there is a 3-stage evaluation, evaluations are taken up by the first evaluator, second evaluator, and the scrutinizer. At first instance, the first evaluator evaluates the answer sheets and awards the marks in the tabulation sheet attached to the answer sheet. Even though instructions are given to the evaluators not to indicate marks in the body of the answer sheets, there are some instances where the evaluators mistakenly indicated marks in the body of the answer sheets. I just want to stop your lordships here. My lords, this is the confusion which has crept before the inquiry officer. Our allegation was not that there was, my lords, use of whitener on the answer sheets You had given marks. My lords, those are there. But that's not our problem, my lords. Our grievance is on the tabulations. Now I'll just proceed further. This is because the evaluators, who are mostly of the teaching faculty, have the habit of indicating marks in the body of the answer sheets. Those marks indicated in the body of answer sheets need to be erased before giving to the second evaluator, as the second evaluator has to carry out evaluation of the answer sheets with independent mind without prior knowledge of the marks awarded by the first evaluator. This is none of our grievance, my lords. This is done because second evaluator would not reply upon the mark allotted by the first evaluator and engage his or her judicious mind carefully. On completion of the evaluation by the first evaluator, the answer sheets were submitted to the commission and the tabulation sheets of the first evaluator was removed by the confidential section of the commission. D, my lords, the answer sheets were then handed over to the second evaluator, who then evaluated the answer sheets independently and without having any knowledge of the marks awarded by the first evaluator. So, my lords, it's all saying about the tampering in the answer sheets. I'm not concerned with that. This is the very reason why the marks mistakenly indicated in the body of the answer sheets, including the answer sheets of the petitioner in Annexure 8 of the petition, which I've just shown your lordships, got erased, white marked by the confidential section before giving them to the second evaluator. The second evaluator then awarded the marks in the tabulation sheets provided along with the answer sheets. There were also some instances where the second evaluators mistakenly indicated the marks in the body of the answer sheet in spite of clear instructions not to indicate such marks. Those were also erased in those answer sheets. This is because no marks were to be indicated in the body of the answer sheets of the candidates. Even after completing the evaluations, the second evaluator submitted the answer sheets to the commission. Again, my lords, nothing with regard to tabulation, white mark on there. Now, E, my lords, after the first and second evaluation were completed, their answer sheets were then handed over to this scrutinizer. Scrutinizer carried out the scrutiny by following the procedure laid down below. There are no rules, I'm just saying, my lords. This for the first time we know, my lords. Your lordships has page 20.
Yes.
General method of scrutiny. Scrutiny of answer scripts takes place after the process of evaluation is complete. Therefore, scrutiny is the final stage of evaluation. Final stage, my lords. Scrutinizer shall receive the answer scripts from the controller of examination, MPSC, only or from the person authorized by him. The scrutinizer shall check if all answers are evaluated. Scrutinizer shall compare and verify the total marks awarded in the answer scripts with the question and shall check for overmarking. Mark awarded is more than full marks allotted for the question.
Now, if there is no marking in the answer sheets, then how is the scrutiny done and the marks allotted in the answer sheets?
There are separate,
No.
separate
So
sheet.
I'm coming to that.
Separate sheet.
Yes,
Yes.
separately. That they'll
My
fill
lords,
it out and submit to the commission.
My friend may not interject yet, my lords. Your lordships,
No,
just
we are
to-
very fair.
I'll come back to this page for a minute, my lords, so that your lordships had raised a very pertinent question. Your lordships may just come to the second page of this counter affidavit, page 82 of this counter affidavit.
And let him complete the next line. That is very important.
Your lordships
I don't,
had
he
raised.
just keep it.
Please don't
intentionally.
interrupt. Please don't
No,
interrupt, Mr.
if you read, then read the
We
whole
are coming
thing.
back. Page 82, my
No,
lords.
no, that is very important. 20 is very important.
No, we're
He
coming.
We'll
indicated-
come back, we'll come back. Let him see whatever.
My lords, page 82 is the slips, the tabulation slips given to the evaluators. So one will put his marks. This will be taken off. Answer script will be given to the second evaluator. Second will give. Now the next page, lordships, the next page at page 83. This is filled by the scrutinizer. This is the final. After this, there can be no more, my lords, alteration or question of using whitener, my lords. This is what I've shown in the earlier annexure to the petition.
No, how does the scrutinizer give the marks?
Yes.
Generally, when the first evaluator and second evaluator are likely to have some difference
Yes,
in each question
yes,
with regard to the marks.
yes.
So how is the final marks given? Is it a total? Is it an average?
In an average,
That's why-
it's given here. I'm
It's an
coming back to
average.
Average.
That's why he just
Page 20.
Ah.
An average only when there is a specific condition met, my lords. Page 20 at para 4, I'm coming to that now. Scrutinizer shall evaluate any unevaluated answer, overmarked or undermarked answers, and enter the same in the slip provided for the scrutinizer. Full stop, my lords. So that's his first duty. In such cases, the scrutinizer shall take average of marks as below. Very important now, my lords. Average of marks given by first evaluator and scrutinizer for each answer, or average of marks given by second evaluator and scrutinizer for each answer, and enter the same in the slip provided for the scrutinizer. Ultimately, the final marks in the slip of the scrutinizer. 6. In the case of direct recruitment examination, where there are first evaluator, second evaluator, and scrutinizer, the following procedure shall be followed for arriving at final marks. If the difference of the total of marks given by the first and second evaluator is less than 30% of the total marks carried by the paper, the scrutinizer shall take average of marks given by the first and second evaluator for each answer and enter the same in the slip provided for the scrutinizer. Same, my lords, if the difference of total marks given by the first or second evaluator is 30% or more, my lords, the same procedure again, there would be an average and it'll be entered in the slip provided for the scrutinizer. 7. Scrutinizer shall check if questions are attempted in excess of the prescribed number. If questions are attempted in excess, only the questions attempted first up to the prescribed number shall be scrutinized and the remaining ignored. No difficulty. The scrutinizer shall check if instructions given on how to answer the questions are followed. The scrutinizer shall check if questions are attempted more than once. Now the important part, my lords, at page 22. The scrutinizer shall check if marks awarded commensurate with the answer and make changes if necessary. If any changes are made to marks awarded by the evaluator, the scrutinizer shall write the new marks clearly and cross out the old one, which I showed in the preceding years, my lords. That was what was followed. For the first time, we don't know who used this whitener, my lords. Nothing. Wrongly numbered or uneven answers shall not be scrutinized. Scrutinizer shall check.
No, have you been given an opportunity to go through your answer sheets?
My lords, yes. Lords, before my lords, in the first instance, when we went, my lords, the controller for some reason did not even allow us to inspect it. Okay, no problem.
No, my lord, they took
no,
photos
let me
secretly
please.
and all it started because they inspect and took
Let
a
me
photo,
finish.
they have the copy.
I don't know what's there to hide, my lords. I'm coming before your lordships with clean hands. The second instance, my lords, we pleaded. We got through the controller. She said, you may please see, we are not providing you certified true copies as you demand. And they did not allow us to take photographs, which my learned friend just said they took secretly. We took,
without taking photograph, how can they have the copy?
Therefore, we are before your lordships. Because, my lords, they misinterpreted one Supreme Court judgment.
No, we are asking you.
Yes.
Forget the photograph or whatever.
Yes.
Have you got the opportunity to go through the answer sheets?
Finally, we got through.
You got through.
Yes.
Now, you have also seen the marks given by the evaluator 1 and evaluator 2? No.
Because my lords, what we've annexed to the petition is the final slip of the scrutinizer. That was attached, and my lords, the signatures were all, my lords, stick-ons were applied on it, so that, my lords, the identity could not be, my lords, specified. That is no problem.
Mr. Counsel for this public service.
Yes, Master.
Are the marks of the first and second evaluator available?
Definitely.
Is
but,
it not
but
possible?
But it will be, because if you kindly see my annexure, it's not
No, their
completely-
grievance is that they suspect that they had secured some higher marks, which for mala fide reasons was redacted by using that whitener, and some other marks was used. Now, this can be sorted out or verified at least
Yes.
by comparing the marks given by the first and the second evaluator and the total given by the scrutinizer.
Yes.
So, why don't you permit them to go through these marks in your presence of a competent officer and then come back?
No, they came. They came and they inspected.
But they said
the slip is, because if you kindly see how we did, there is a separate slip, then that will not be seen by that second evaluator also.
No, that we know, but that first slip by the first evaluator, second slip by the second evaluator,
Yes,
these will be available before the scrutinizer.
yes,
Has to be,
yes.
so that he can find out who has given what marks and
I
how
think
the
I have to
average.
seek the instruction from my client.
You have to.
Yes.
So all we are saying is
I
that you give them an opportunity, say, have them have their
That is-
satisfaction
That is fair.
before the competent authority in the civil service
Yes.
commission, and then we can come back to decide whether there's any further thing to be argued.
Well, actually, like even considering their prayer is only
We
seeking.
we are suggesting this way out so that not to take the trouble of calling for the records and verifying it
That's
ourselves.
fine, fair enough, my lord. But admitting that also, hypothetically, that because they challenged two things only, they did not pray for stay order of the further examination. Also, one is that this examination, the result, only then that two things.
See, the first thing that we would like to know is, was there any discrepancy,
Yes.
shortfall, misgivings in the marks allotted by
Yes.
the commission?
Yes.
Let this doubt be cleared.
All right.
Assuming if there is none, then there's nothing remains in the petition.
But still, my lord.
If there is, then we'll decide
If
whether
there
we
is-
should
if
pass
there
an
is
order.
Still, if that their prayer of that shutting aside of the result is allowed, then
No, we are not saying we'll allow. We are saying
no,
that
in case it is allowed, what is there, my lord? Because
no,
they already joined.
we are not definitely, we are only trying to address an issue which is before us.
Yes.
Right? So the issue here is that there is some illegality committed in allotment of the marks.
Yes.
The procedure has been explained. Now their grievance is that some marks was allotted, whitener was used, and it is their suspicion, they suspect.
My lord, kindly go to the report, inquiry report, then explanation will be there. Please, one more, that without going to.
Where
because
is
the
that?
report,
Where is that report?
that it start from 53.
Let me read my notes.
53.
Yes.
It's not to.
It was explained very clearly why whitener was used in this respect.
My lords, page 53, steps of inquiry at.
No, we are not on the question of whether whitener should or should not have been issued. We are not remotely into that. We are trying to address the issues raised before the court, that the whitener was used to remove the higher marks which they have got.
My lord, in
Right.
fact,
Now, in order to arrive at that, the only thing that is necessary is the marks given by the first evaluator, second evaluator.
yes, my lord, I got it, my lord. In their petition, this is new issue raised as of now, because one is that tampering, because they have never raised this tabulation anymore. Today only they raised this new issue.
Their prayer is for quashment of the notifications of 2311, the results. Right. Now, if this prayer, obviously, this court would not be inclined to allow this prayer
Yes.
as an omnibus, because that will affect the other candidates who may have been selected.
My lords, they are party to this petition.
Maybe.
Yes.
My lord,
But
that at least that
you are
maybe-
aggrieved,
my
you
lord,
are,
that at least
you
that
are aggrieved by alleged reduction of marks,
Tampering, my lords.
tempering of
I
it.
cannot see if it's reduced or.
All right, tempering.
Yes.
This tempering is to suspect that there was reduction,
My lords.
right? Let us hypothetically give an example that you are given 50 marks.
Yes.
Because of some thought, mistake or understanding or whatever, they used a whitener and again put 50 marks. It doesn't affect you. There was tempering,
Yes.
but it doesn't affect you, right? So it affects you only when your marks are reduced. So assuming that is there,
Yes.
then your claim would be in respect of those, how many petitioners are here?
My lords.
two only.
Two petitioners.
They-
Would be in respect of those two candidates
Yes.
who were last in,
Yes.
right? They will have to come out, you'll have to give them the opportunity to argue, etc., etc. Now, everything depends on whether there was tampering to reduce your marks.
My lords, there is one catch there, my lords, if I may just put it. Inquiry report, inquiry officer himself says, in the top 50 people, there is also similar use of whitener. Now, my lords, there is one hypothetical situation which probably has arisen or may arise, is that, my lords, in as much as you may alter one candidate's marks, whether higher or lower, you are similarly, my lords, tampering the marks of somebody who has got in.
No, if that be so, then we'll have to satisfy ourselves, and then we'll have to direct proper inquiry by
Yes,
an independent agency.
That is what we're seeking, my lords.
My lord,
We want that first. We may be wrong. What is the issue, my lords? Ultimately, this will
No,
be...
for the court even to be satisfied to issue an inquiry at this stage,
Yes,
I'll have to be satisfied whether these
justifications can come.
justifications are there or not. And there is one more thing, is that again, I at the cost of repetition, I say that this is not a PIL. Right.
Problem is,
You are essentially aggrieved by your non-selection,
yes,
and subsequently you've been selected.
yes,
You're working now.
yes,
So, setting aside of the proceedings and holding a fresh inquiry today
yes.
will affect the other candidates who are already in service.
My lords, it is true. But, my lords, and
There has to be independent finding that
Independent.
at least those people who are appointed, they were wrongly appointed, wrong marks was given.
I completely agree what is followed
Right.
from your lordships. So, my
So
lords,
we are only confining this to see if there's any relief can be granted to you
yes,
so far as these marks are concerned.
yes.
And if these marks are there, were wrongly not given to you, then what reliefs can we grant?
My lords, I understand. My lords. It is a sort of a predicament.
my lord, that's, my lord, actually my humble prayer is that at least observation be there today, order, then direct us to allow them to inspect their report, then it is short of case, then it can be solved.
My lords, can I
You know,
just...
what,
Observation that this is not a PIL, then we cannot set aside.
of
the
course,
point-
this is not a PIL, it's not
Yeah,
numbered as a
that's-
PIL.
at least-
Why
at least it is
observation is
there.
necessary?
Because some other judge might come, they might have
No.
think any other different opinion. My lord, my point is that have the.
There is no opinion.
Actually,
You see,
now,
we are only thinking aloud.
actually
The
nowadays,
problem with this bench is that it can't keep quiet.
my lord,
It keeps on thinking
Lord,
aloud.
what I would like to say is that nowadays everything is online on YouTube because, you know, in Supreme Court now our problem is that the observation, it's almost think that the people, the clients, you know, they consider it is a binding nature.
It is for
If
you
it is
to,
there,
it
at
is for
least-
you to impress and advise your clients that the
Standing counsel.
orders of the court are what goes in the order sheet.
No, I'm not saying that because now I'm sure that all the private respondent might be seeing tomorrow or tonight also these again. Those who have not come.
Maybe. We are only trying to see what remains. If you give us your, you see, the claims is that there is some discrepancy going on
Yes. But
regarding
because,
these
my
two.
lord, actually, the
Which-
reason why
which-
they did not come forward is that because they have seen good observation in their favor. That's why they just, you know, will not pass any.
We are not interfering their appointments as on date. We
Yeah,
are not.
that is at least can it be reflected today?
No, we have not, when we are not interfering with the appointments, where is the question of reflecting it to say that we
Okay.
are not appointing?
Okay, that is,
We are
I'm
not-
glad that. Because
We are
what
not
we,
inclined to do that.
yes,
As on today, as things today, stand today. We're only asking you from your records, because that would have clinched the issue.
yes.
When you had shown the papers to them, it would have clinched the issue that these are the evaluations made and this is the final marking of the scrutinizer. Then they would have accepted or not accepted.
My lord, just before that, because we have not see the conclusion of the
Yes.
actuarial report, just the very conclusion. At page number 68. This very detailed, minute observation.
68,
68.
yes, conclusion.
Yes, conclusion. So I substantiate that I do not see any changes nor mutation make in 2023 answer scripts of the Mizoram Civil Service Combined Competitive Examination.
Our grievance is not with answer script.
My lord,
Our grievance is with the tabulation, my lord.
no, my lords, they have
That
never,
is the problem with the
my lord,
inquiry
even in a single word, single sentence that they have made this regarding tabulation at all.
It's
So
in
through
item
entire process, right from the beginning only, today only they stated this tabulation. Because they say that tampering. No, that they came because they alleged MPSC had
No,
tampered.
no, in your answer sheets, as per your rules, you are not allowed to, evaluators are not allowed to give marks.
Yes.
But sometimes, by mistake, they
By
give the
mistake,
marks.
1, 2, 3 only, that is very rare.
Right, and then it is erased by the
Whitener.
whitener.
Yes.
Because this same answer scripts will be evaluated by the
The second.
evaluator number 2,
True,
right?
yes,
So therefore, the marks are not required to be reflected,
definitely.
right? But the question remains is, how was the evaluation done by the 2 evaluators?
Because it is a separate slip that I have enclosed it also at my last annexure.
I've shown your lordships at
My lord,
page
there,
83.
because it is there. You also kindly go to the last annexure. The sample I furnished to the court, the sample how they did. This is how they use
83, my lord.
83.
Right.
My lord, then after first evaluator, 82 and 83.
Sorry?
82 and 83.
Yes.
82, you'll see this is only sample. It is separate sheets. Actually, I just make photocopies and enclose here. So you'll see first evaluator,
Second tabulator.
and this will be carried out, and it will be given to commissioner. And second evaluator will not know anything. To apply his independent mind, second evaluator will only write the marks over here, tear it, and give to the commission. No one will see it. Very fair. They did not know that how fair we are.
And then,
And then the third, then check the first and the second we have read out. We take average, then that which we have read in the para 18. This is how a process.
right.
So, my lords, why is there the whitener specifically?
Because whitener, if there is a whitener, if the mark is there, second examiner might simply rely upon the evaluated mark.
No, no,
Definitely
not
we
in
want-
the answer sheets. It's
Yeah,
referring to
yes,
the, it's referring to this tabulation sheet.
Yes, yes. Tabulation sheet might not, normally we don't give even when they come in.
Therefore, there, everything rests in the tabulation sheets. You get your instructions from
That
your
we can, I
client.
think that might not be a problem, but this issue have never raised before. Now, kindly see the petition and lordship, read the grounds, everything. Read one by one, sentence by sentence. This issue have never been raised.
It is an admitted
No, let
possession.
me tell the court, let me inform the court that that issue has been never
Let it
raised
be
also.
raised.
No, but his prayer is for setting aside of the notifications.
Yes.
Quashment of the proceedings.
Yeah,
Institute a proper committee of experts. These prayers are still available.
yes. That's
These
fine.
prayers are still available.
But still regarding that tabulation,
And your lordships can always mold the reliefs in.
Then it says to initiate investigation into the tempering of the answer sheets.
if the lordship is not satisfied with the inquiry commission established by the state, that is. we can
Inquiry
do it.
commission does not say anything on the tabulation sheets.
My lord,
Yes.
my lord,
Inquiry
just a-
commission gives a report on the answer
Answer
sheets.
my lord,
There's nothing about tabulation sheets. You show us from the inquiry commission.
My lords, also myself.
actually, their allegation is that only tempering. Since there is no
The
tempering,
inquiry was conducted by the commission.
yes, not
The,
by us,
by whom?
by the independent inquiry commission.
Who ordered it?
The
State
actually
vigilance.
the state vigilance department.
Vigilance, all right.
Yes,
But the inquiry commission did not answer this issue of
Yes.
the temperings.
yes, it's
The-
addressed.
No.
There's no
Page number
69. There was no change.
No.
68.
Your lordships.
68.
68.
This is only with regard to answer sheets,
Yes.
Yes.
answer scripts.
He's saying yes, myself.
What about the tabulation?
My lord, actually, there is no allegation regarding the tabulation at all.
May not be. Therefore, we are saying that according to the code, the The dispute is with, not with the answer sheets. Dispute is with the tabulation sheets.
Yeah, my lords, page 57.
That can be sorted out by comparing the evaluations given by first evaluator, second evaluator, and the final marks given by the scrutinizer.
My lords,
If there is no defect there, the matter ends. We close the matter.
I got it, I understand that, my lordship.
but my lords, if your lordships are going to direct that, my
No,
lords,
we are not directing, we are permitting the standing council to obtain the instructions whether you will permit that or it is available.
yes, we
If
can
it is
also be
available-
part of, my lords, seeing the records.
Yes.
Because again, if it gets tampered, what knows what happens?
Oh,
Nothing.
that is already there in their
Yes.
custody by virtue of that IA. They have been asked not to dispose it off. You get your instructions, when can you get it?
I can get today evening also.
Today?
And
Yes.
All right.
if your lordships is convenient, may I have it, my lords, post lunch?
Tomorrow also we can continue.
All right, we can. Tomorrow is
DB.
DB.
Or day after, my lords?
Day after?
Yes, Lord.
Right. Matter to be heard again Thursday. Meanwhile, the Standing Council, Mizoram Public Service Commission will obtain instructions as to whether the petitioners can be permitted to, whether the petitioners can be shown the tabulation sheets. of-
Their marks only, their,
tabulation sheets
Yes.
of the first evaluator, second evaluator, and also the scrutiner, insofar as the marks obtained by the writ petitioners only.
yes, that's what I would,
Release this matter again on Thursday.
much obliged. Lord.
Mr. Jordan appears for the petition.
Under my name, eh?
Your-
J.
your
J.
mis-
Silan is,
Mr.
J. Silan is there.
J.
Hearing the cost title.
Okay. Appears for the MPSC.
Yes. And government,
J.C. Lalnun Sangha appears for the MPS.
and government, additional
Who's
government.
for the government? Mr. Samuel, additional senior government. Additional AG, I'm so sorry. Additional AG for the state of Mizoram. Released on Thursday.
My lords.
Part 2, item number 3. Any councils present?
Yes. No one is present.
My lord, I believe all the other councillors are absent, my lord. Apologies, my lord.
You're submitting on behalf of the state or on behalf of the bar?
Bar.
All right. Done?